Mr. President, first of all, thank you for taking the time to talk with
us.
When you signed the National Defense Authorization Act into law, you issued a signing statement at that time that said you would not use that power for indefinite detention on Americans. You understood the concerns that people had. A judge earlier this year issued that the administration couldn't use those powers because it's unconstitutional. So why are the government's own lawyers fighting that judge's order, the injunction in particular?
I do want to read, though, a quote from Judge Catherine Forrest's ruling. It states, quote, "Due deference does not eliminate the judicial obligation to rule on the properly presented constitutional questions. Courts must safeguard core constitutional rights. A long line of Supreme Court precedent adheres to that fundamental principle in unequivocal language." So, Tangerine, I want to ask you to talk more about what parts of this law raised questions of constitutionality.
Well, you know, she addressed that pretty strongly with a couple points yesterday, actually a lot of points. And two of them are, firstly, that several of the terms you mentioned, one of them associated forces, material support, independent journalism, which was newly introduced, that those remain vague and the government either could not or would not define those for us. That's actually unconstitutional, according to Judge Forrest's ruling yesterday. It runs counter to the due process clause of the First Amendment. So they have to define their terms, and she told them that yesterday in no uncertain terms in that ruling. Secondly, the government has tried to claim repeatedly that the court should only intervene with a habeas review, not judicial review. What that means is you've already lost your rights to due process if the government gets its way, and the best you can hope for if you're indefinitely detained is that someone somewhere down the line demands a habeas review and demands that you're brought before the court. So she said, no, absolutely not. It's my duty. It's our duty to step in and say due process is guaranteed by the Constitution.
Well, look, the basic principle here is, number one, my first job is to keep the American people safe. Number two, we've got to do it in a way that respects our values and our traditions of rule of law. That's why I ban torture. That's why I've argued that we should actually close Guantanamo. But I've also said that, you know, we've got some bad guys who are down there who we may not be able to try in a traditional court, but have pledged to try to hurt Americans. And so that's something that we inherited, that we're dealing with, and it's complicated. On the other hand, what I also said was a U.S. citizen can never be subject to that kind of detention. Congress disagreed with me.
And I'm wondering whether the senator is familiar with the fact that the language which precluded the application of Section 1031 to American citizens was in the bill that we originally approved in the Armed Services Committee, and the administration asked us to remove the language which says that U.S. citizens and lawful residents would not be subject to this section. Is the senator familiar with the fact that it was the administration that asked us to remove the very language which we had in the bill which passed the committee, and that we removed it at the request of the administration, that would have said that this determination would not apply to U.S. citizens and lawful residents? I'm just wondering, is the senator familiar with the fact that it was the administration which asked us to remove the very language, the absence of which is now objected to by the senator from Illinois?
I'm familiar now because the senator from Michigan has shared that fact with me.
And I didn't want us to not be able to finance our military and pay our soldiers and our troops. So I signed the bill, but what I also said was, look, that I'm never going to use this power, and you know, what I would suspect is that the courts are going to agree with us over the long term that that is not something that you can use when it comes to U.S. citizens.
President Obama wants to make clear that under his administration, that the executive branch will not detain U.S. citizens, since he's given the option in this bill, basically with the vague language, because one portion definitely states that he can detain U.S. citizens, okay? So he attaches a signing statement that objects to sections 1021, 1022, 1023, 24, 25, 26, 27, 28, 29, 1231, 1240, 41, 42, 45, 44. So, in other words, he objects to an enormous portion of this bill, but nonetheless, he will sign it into law. Now, if you remember, we objected greatly to signing statements under George W. Bush. That was, of course, in a different era where now, apparently, if you're a Democrat, you're supposed to say signing statements are fantastic. Now, why do we object to it? Let me jump to graphic number 6 here. Now, this is in the signing statement from President Obama, and it gives you an excellent sense of why we objected to signing statements, whether they're under Republican or Democratic administrations. Quote, should any application of these provisions conflict with my constitutional authorities, I will treat the provisions as non-binding. Excuse me, but what the hell is that? Did you guys, did any of us take civics courses? Did President Obama take a civics course? He taught constitutional law. Where in the Constitution does it say, hey, by the way, a president can sign a bill, but then say that I can treat any part of it he doesn't like as non-binding? That's the most unconstitutional thing I've ever heard. That's totally not within our government to say, hey, you know what? The president is basically can do any damn thing he likes. He can take a law and say, I like Part A, I like Part B, but I don't like 18 other parts. I'm glad you passed it in its entirety, and I signed it in its entirety, but that is not how I will execute the law. It's ridiculous. It was ridiculous when Bush did it. That's why we were so mad about it. It's still ridiculous under Obama.
Early this year, a group of journalists and activists sued the government. The claim, the indefinite detention clause violates the due process clause of the Constitution. Judge Catherine Forrest agreed with those journalists, issuing an 8-page memorandum in which she said that indefinite detention cannot be used on any of America's own citizens, saying, quote, in the face of what could be indeterminate military detention, due process requires more. Well, instead of abiding by the injunction, the White House has appealed it instead. Tangerine Bolin is an activist who voted for President Obama in 2008. She's also one of the plaintiffs suing the government over this issue and writes about the latest hearing on this issue, saying, quote, Obama's attorneys refused to assure the court in the latest hearing, when questioned, that the NDAA's provision, one that permits reporters and others who have not committed crimes to be detained without trial, has not been applied by the U.S. government anywhere in the world after Judge Forrest's injunction. In other words, they were saying to a U.S. judge that they could not or would not state whether Obama's government had complied with the legal injunction that she had laid down before them. To this, Judge Forrest responded that if the provision has indeed been applied, the United States government itself will be held in contempt of court.
Is that the courts are going to agree with us over the long term that that is not something that you can use when it comes to U.S. citizens.
Well, now, are there portions of the signing statement that I like? Yes, but the problem is, one, you can't have a signing statement be constitutional if you ask me. I think if you ask any decent law professor. And then number two, other administrations and other courts will not take this signing statement as law because it isn't law. It is the president's opinion about a law that he's actually putting into effect. Now, let's go to the parts that I kind of like, but show you the problems with those as well. So he says in his signing statement, I have signed this bill despite having serious reservations with certain provisions that regulate the detention, interrogation, and prosecution of suspected terrorists. Now, I like that he has reservations with it. A lot of people will read that sentence and go, that's it. See, I knew Obama was on the right side. But the fact that he has reservations is irrelevant. The fact that he signed it is the only relevant thing. You can have all the reservations that you like. If you signed the damn thing into law, it's law. Now, second part. He says, I want to clarify that my administration will not authorize the indefinite military detention without trial of American citizens. Indeed, I believe that doing so would break with our most important traditions and values as a nation. Now, again, I like those statements. I think a lot of people look at those statements and go, I knew Obama was on the right side. Says he won't do the indefinite detentions. In fact, it's against our core principles. But the key words in those sentences, my administration. I want to clarify that my administration will not authorize the indefinite military detention, meaning the next administration is perfectly free to do that because it is the law. You signed it into law. You don't get to say, hey, you know what, if it's President Romney or President Gingrich, then he has to have the same interpretation of this law that I do. And in fact, he doesn't even make that claim. He just says, my administration won't do it, but it'll be law, so you can be indefinitely detained later. Good luck to you. I don't know if it's part of his re-election campaign to then turn around and say, see, you don't want to elect a Republican. because they might indefinitely detain you. Whereas I signed it into the law, but will, out of the goodness of my heart, choose not to do it until I change my mind. He continues in the signing statement, my administration will interpret Section 1021 of the bill in a manner that ensures that any detention it authorizes complies with the Constitution, the laws of the war, and all...
Please understand the law as it is today and is going to be after this bill is passed. We're at war. The authorization to use military force passed by the Congress right after the attacks against this nation designates Al-Qaeda as a military threat, not a common criminal threat, so we apply the law of war. There are two legal systems at play here. Domestic criminal law that's well serves us as a nation to deal with crime. Even the worst person, the worst child abuser, gets a lawyer and is presumed innocent. Believe it or not, war criminals get lawyers and are presumed innocent. I'm proud of both systems, but the law enforcement model doesn't allow you to hold someone for a period of time to gather intelligence. Under the law enforcement model, once you capture someone, you have to start reading them their rights and providing them a lawyer. Under the law of war model, you can hold someone who's part of the enemy force and gather intelligence, and this is not the first war where American citizens have sided with the enemy.
Again, key sentence there. My administration will interpret Section 1021. That is the most offensive section in the bill. But it's still in the bill, and they could choose to have a different interpretation on a different day. We are supposed to be a country of laws, not of men. We're not supposed to depend on the benevolence of our leadership, okay? Laws are laws, and he just signed it into law saying, yes, my administration, future administrations can indefinitely detain you, which, by the way, goes to that point. The people who said, hey, you know what? Oh, no, this bill says that the previous laws are in effect, and you can't indefinitely detain citizens. Really? Then why does the president keep talking about it in his signing statement? Obviously, he thinks that the bill does allow for that. He's saying the bill allows for it, but my administration will choose not to do it.
If it's an American citizen, say, over somewhere in Pakistan, that is plotting and seeking to kill or destroy American citizens, it's okay for us to send a predator and fire and kill that person. But according to the Senator from Illinois' interpretation, if that person were apprehended in Charleston planning to blow up Shaw Air Force Base, then that person would be given that individual's Miranda rights. Now, how in the world does that fit?
And also about the so-called presidential kill list that's gotten a lot of attention, and this list of folks who have been targeted for assassination. Right. And on that list have been U.S. citizens who have not been afforded trial, including Anwar al-Awlaki. How do you, as president, or any president for that matter, regardless of party or person, utilize that power to assassinate even U.S. citizens?
Well, first of all, you're basing this on reports in the news that have never been confirmed by me, and I don't talk about our national security decisions in that way.
And to those American citizens thinking about helping Al-Qaeda, please know what will come your way. Death, detention, prosecution. And when they say, I want my lawyer, you tell them, shut up.
Your time is expired. The judge has ruled, put in this permanent injunction, and has made it so that part of the law cannot be enforced. Are you now comfortable with the NDAA, the law as it stands now?
Well, I was thrilled for the last 24 hours, but just before we got on this call today, they actually appealed the ruling.
Is that the courts are going to agree with us over the long term that that is not something that you can use when it comes to U.S. citizens.